Good afternoon. My name is Deborah Glatter, and on behalf of the Law Society, I'd like to thank you for coming out this evening and to welcome you to this program. I don't think it's news to this particular group that we have a lot of problems beleaguering us today as practitioners in the area of law. The public's perception of us is not good. We are seen, generally speaking, as deal breakers, not deal makers. We're seen as people who take a dispute and turn it into a blood feud. Often, the public thinks for our own personal profit. It's safe to say that a lot of us, because of that public perception, don't find the practice of law a particularly satisfying experience today. But what ADR offers us is an opportunity to revisit how we approach the practice of law and how the public perceives us in what we do. It takes us, I think, a step closer to what lawyers were a generation or two back, helpful advisors that facilitate the client's needs, gets the client what they want, and often gets the client what they want outside the narrow cookie cutter of what the justice system can mete out. Hopefully, with the advent of ADR and other creative options now available to us as practitioners, we'll find the practice of law again a satisfying experience the way it was a generation or two ago. Our panel today consists of people who enjoy what they're doing, I think. Is that safe to say? Absolutely. You can refer to their very scaled down bios on this piece of paper that you should all have in front of you. If you don't, they're standing, they're in a heap somewhere, and if you see them, please pass them around to your colleagues. Thank you. I see them going around at the top there. You can see that all of the members of our panel are at the cutting edge of dispute resolution, and I'm honored to welcome them here today. To start with, I'd like to call upon our chair, Rick Weiler, to present to you his very dynamic approach to ADR. Rick?
Thanks very much, Deborah. Everyone can hear me okay at the back there? Great. I know it's been a long day, 5 o'clock. People are kind of feeling like this, but you can hear me. Paul, you can hear me back there, right? Fabulous. Fabulous. Okay. And Deborah, thank you for that introduction. I don't know how dynamic it'll be. I suppose it'll be great if I don't trip over the cord and carry on in that way. I want to start off just by welcoming everyone here. We have a very full agenda over the next 2 hours, and we are also very conscious of the commitment that you have made by being here, spending a couple of hours with us in this program. And I and the panel members want to be as responsive as we can to that commitment as we present the material that we have for you. Unfortunately, given the size of the group, and I understand there's approximately 280 people signed up for this program, we will not have a lot of time for back and forth question and answer. I can tell you, though, that those of us on the panel will be around a little bit after the program, and certainly will be happy to talk to you about any specific concerns that you might have. Well, ADR. You notice we've called it, by the way, appropriate dispute resolution. It's everywhere, isn't it? ADR, it's everywhere. The Canadian Bar Association this week in Vancouver, the report that was issued there, many of you will have seen the reports in the paper about that. The ADR Centre here in Toronto. The editorial in the Globe and Mail yesterday morning. Where else? The rule amendment for the Law Society. Everywhere you turn in the last couple of months, ADR. And it appears at this stage, and I'm sure one of the things that's brought many of you here, is that this, just maybe, is not flavor of the month. Just maybe there's a trend line here that we're starting to see. Just maybe there's something here that we in the legal profession need to become more aware of, and need to add to our toolkit. And I want to sort of get that out of the way right off the bat. We're not here to tell you that this is the panacea, this is the golden way, this is going to solve all your problems and your clients' problems. We're here to suggest that the approaches, the principles of alternative, appropriate dispute resolution, there are tools there that you can take regardless of your practice area, whether it's criminal or family, corporate, commercial, whether you're a barrister or a solicitor. You can take these principles, these tools, and incorporate them into your practice in the best interests of your client, and also in ways that will work for you. In a 2-hour program, obviously, we don't have the opportunity to go into a tremendous depth in any of the material we're going to be presenting to you. But we thought, in terms of presenting an ADR primer, that it would be important right off the bat to present in a very straightforward and hopefully understandable way some of the fundamental principles that all this ADR stuff is based on. And so in the first few minutes of this presentation, I'm going to go through a series of overheads that will hopefully do that. Everyone I know has received the red book here today, the ADR primer. Our participants have papers in there. The material that I'll be going through and the overheads I'll be referring to are in the A section, the start section, so that it is possible to follow along. Again, my hope is that in presenting these principles and presenting these ideas that undergird ADR and give you a sense of how these processes work and how they fit together, that it will increase the understanding and give you some information that you'll be able to apply then when you listen to the subsequent speakers. I want to start off very simply, something that we in the practice of law know all about, conflict, and suggest a very simple definition of conflict, that conflict can be defined as a form of competitive behavior, a competition between actual or perceived incompatible goals or limited resources. In the practice of law, particularly in litigation, we're often involved in disputes where the conflict that sort of surrounds everything, this competitive behavior that in many ways characterizes our existence, bubbles up into disputes and lawsuits and claims and complaints and appeals. But for the purpose of what I'm going to be saying over the next couple of minutes, I want us to sort of back away from that and look at this very broad definition of conflict. It's trite to say it, and I'm tempted not to say it, but we live in a world that is characterized by incredible change. All of the technologies that we are dealing with, that our clients are dealing with, are changing daily. Those of you that are on the internet will have some sense of just this tidal wave of information and change that is all around us. We make the point here that conflict is linked to change. Conflict arises as we and our clients attempt to negotiate our place in the face of that constant and accelerating change. One way to think about ADR and the processes we're going to be touching on is to think in terms of technology. The technologies that we use, the technologies that our clients use daily, have moved forward very rapidly. Our technologies of dispute resolution have not moved forward as rapidly and are now struggling to catch up. The processes are there, the principles are there, but we in the legal profession are struggling with how we can modify the principles, the processes that we're talking about to meet the change that is facing not only our clients but is also facing us. We know that there is a cost to conflict. Our clients well know it, and we know it as well. Too often we think in narrow terms about those costs of conflict. We think about the money. And yes, the money is important. There's no question about that. But we also understand that there are a full range of costs associated with conflict. And I'm going to come back to this concept of cost of conflict, but I want to sort of plant the seed with you now to understand that we have a range of costs. Transaction costs largely are the money costs, but we also have lost opportunities. The low satisfaction level that comes from poorly managed conflict. How satisfied are people after they've been involved in a long, drawn-out lawsuit or some other kind of administrative appeal procedure? Satisfaction levels with our traditional methods of dispute resolution are fairly low. We know that. Recurrence, the same kinds of disputes happening again and again. There are costs associated with that. Relationships. We know that adversarial approaches to conflict management are extremely costly in terms of relationships, whether they're family relationships, business relationships, just societal relationships. There's a high cost. There are a whole range of interests that people have when they come to conflict, and to the extent that those interests aren't met, there are costs associated with that. This then is one of the principles that we have to understand when we're talking about alternative dispute resolution, is the cost of conflict. Many of you here deal with financial statements all the time. You'll know that on a profit and loss statement, there is not a line item that says cost of conflict. It's a principle that's unknown to generally accepted accounting principles. But where the penny is dropping with organizations, financial institutions, government agencies, the Law Society, where the penny is dropping is that if we look at all of these costs in any kind of situation, and if we were to put those on one line, it'd be a big number. And so finding ways, finding approaches, finding processes that can help us reduce and significantly reduce these costs is a big part of what alternative dispute resolution is all about. Now, I want to suggest to you that there are essentially three approaches to resolving disputes. Three approaches, and they're interlinked in the way that you see here. Those three approaches are interests, rights, and power. Disputes are resolved on the basis of interests, rights, and power. Power-based approaches to resolving disputes are approaches which measure the power, the resources of the parties. Who's left standing at the end of the battle? Who has the resources to sustain the fight? Power-based approaches, example of power-based approaches, the big one, the obvious one, is war. Very popular approach to conflict resolution in our century. But there are others. Strikes, for example, are a power-based approach to resolving conflict, a process that measures the relative strength of the parties. Lockouts, of course. Interestingly, votes, referendums, are also power-based processes for resolving conflict. They very simply measure the strength, the power of the parties. One of the problems with power-based approaches is that they lack predictability. People here, many I'm sure, are students of history. I don't need to elaborate to say that there are many times when a party, an army, an individual, a situation where one party seemed to have more power on paper, or as you counted the soldiers, in fact did not prevail. If I say David and Goliath, it makes the point. Power-based approaches to conflict resolution lack predictability, and we also know that they exact high cost. And I'm referring to that full range of costs that I had up there a moment ago. Let's move to something we're all very familiar with, rights-based approaches to resolving conflict. These are approaches to resolving conflict based on the rights of the parties. Where do these rights come from? The obvious places, again, that we're all familiar with. They come from statute and bylaw and regulation, and court decisions, and precedent, and contract. All the ways that rights are created in our society. And rights-based approaches to conflict resolution are approaches that attempt to determine who's in the right and who's in the wrong. The processes, of course, the principal one that we're all familiar with is court, litigation. This is the major process that we have for resolving conflict on the basis of rights. Arbitration is typically another example. And finally, we have interest-based approaches to resolving conflict. Interest-based approaches. You know, I know there's some frustration out there as ADR has grown, and many have suggested that it's a field that in many ways is jargon challenged. Interest-based approaches. You know, our book here, Getting to Yes, the Bible of interest-based approaches, Fisher and Urey. Interests. What do we mean by interests? Very simply, wants and needs and fears that individuals have. Those are their interests. Those wants and needs and fears. Those give rise to conflict, and approaches that attempt to resolve conflict based on the interests of the parties. The principal one, of course, is negotiation, something we do all day long. We negotiate. We negotiate, whether we know it or not, in a way that attempts to make other parties aware of our interests, and hopefully we find out what the interests of other parties are. Interest-based approaches to resolution of conflict, principally negotiation, but others include facilitation, conciliation, and mediation. And I'm going to come back and talk a bit more about mediation. So then we have these three approaches to resolving conflict, and they are interlinked. That's why these circles are linked together like this. We know that when we negotiate or when we mediate, we don't do that in a vacuum. We have our rights. There's also issues of power in any kind of dispute. If it's a small business that's in conflict with a large financial institution, we know that the reality of the situation is that power plays a role in that, certainly rights and interests. Fundamental to the ADR movement is this principle, which is supported, and there is a bibliography, by the way, in the back of your material, the very back page, but this principle, which is supported by a fair body of academic research and writing. This principle that says that generally, interest-based approaches have a lower cost than rights-based approaches to resolving conflict, and that rights-based approaches typically have a lower cost than power-based approaches. Interests, then rights, and finally power. This principle then gives rise to the sequencing that you see on the overhead. That in any given conflict situation, if our job, as it is as lawyers so often, is the effective management of conflict, we should be thinking in terms of sequencing our approach, interests first, then rights, and then power, keeping in mind that they're interlinked. This principle then can be illustrated in this graphic, this stairway. Are there any Led Zeppelin fans in the crowd here? Come on. Yeah? This is not the stairway to heaven, right? This is a stairway, this conflict management stairway, that is characterized as you go up the stairs by increased hostility, increased cost, keeping in mind all of those costs that I mentioned before, and decreased control. The parties that are in conflict have decreasing control as they head up this stairway. We're not here to say that when it comes to ADR, any particular process is the right process. We know, based on a lot of research and a growing body of research, that mediation is the single most effective process for overcoming barriers to settlement and for meeting the interests of the parties, those wants and needs and fears. But we also know that it's more complex than that. And I suggest that a big part of your job, and a growing part of your job as we head into the future, will be understanding that there is a full range of processes. Indeed, processes can be designed to meet particular dispute situations. But there's mini-trial and neutral evaluation, meet-arb, fact-finding, a range, and a growing range, as I say. For you, assessing, first of all, understanding those processes, and understanding the strengths and weaknesses of those processes, and matching your disputes and your clients' disputes to those processes, I suggest will be a big part of the practice of law as we head into the future. It's been suggested that at some point in the not too distant future, the concept of litigation lawyer or litigation department may be a thing of the past. And in effect, it's then the new word would be, or the new phrase would be, conflict management department and professional conflict manager. Just briefly looking at this stairway, and I just want to briefly work my way up the stairway just to give you a sense of what each of these steps represents. Prevention, obviously, if we can prevent disputes, we know conflict is a constant, but if we can prevent disputes before they ever get started, that's the lowest cost, and that's something that seems to be desirable to everyone. The prevention of conflict will require problem-solving skills, something this group has an abundance of. But what are the processes, what are the tools at that first step? One is the concept of a multi-step dispute resolution clause in agreements, in contracts. And we're starting to see this increasingly. You know, when I first started practicing law in the late 70s, the arbitration clause in an agreement was rare. Now we see increasingly in bank documentation, landlord leases, franchise agreements, this concept of a multi-step dispute resolution clause. In your material at the end of tab A is an example or a template of a sort of a for openers approach, just to give you a sense of what we're talking about with a multi-step clause. Basically a clause that says if there's a dispute, you know what, we're going to sit down and talk about it. And if that doesn't work within a certain period of time, then we'll go to mediation. And if that doesn't work within a certain period of time, then we'll go to arbitration. Obviously, the clause has to be tailored to the context, but this notion of designing our dispute resolution process is taking into account this stairway. Awareness training, boy, there's a ton of that going on in this city. Training that makes lawyers and others and client groups, and I think this is another area of growth for lawyers, is training that focuses on effective approaches to conflict management, the very kind of thing we're talking about here, helping our clients to understand that and incorporate it into their organizations, their practices, their procedures. And finally, partnering. Partnering as a preventative process is a process that, for example, in a large construction project, a joint venture, a syndicate, anytime there's a strategic alliance, gathering the parties ahead of time and having them focus on the reality that there is going to be conflict in their relationship and thinking proactively and creatively about how that conflict is going to be managed. Partnering is a growing process here in Canada. It's been used very effectively in the United States for a number of years. The next step on our stairway, simple negotiation. And for lawyers, continuous improvement, continuous learning about the art and science of negotiation, I suggest to you, is a must. It's not an option. For those of you that haven't read this book, Getting to Yes, all kidding aside, pick it up on the way home. This book is really a foundational piece in terms of understanding new approaches, obviously, well, they're not that new now, and effective approaches to managing conflict. Interest-based approaches. We know that there are other styles. There is an accommodating or cooperative style. Many of you will have seen the video and the work that Professor Jerry Williams from Brigham Young University has done for the Law Society, highlighting strengths and weaknesses of accommodating negotiating style and aggressive negotiating style. There's a fair body of evidence to indicate that interest-based approaches yield better results than either of those two approaches to negotiation. Our next step was entitled Standing Neutral. The concept of a standing neutral is that typically in an organizational or project setting, that there is someone who is close to that project or organization, may in fact be employed by that organization, who is seen as an acceptable party to resolve disputes, is aware of the context, is aware of the systems, and is on hand to help resolve disputes. An ombudsman is an example that probably we're all familiar with, but project mediators are becoming a more frequent occurrence on large construction projects. Again, what we're talking about here is someone, a third party, who has got a non-binding, is not a decision maker, is there to facilitate, is there to assist the parties in reaching their own solutions to the conflict. The next step, non-binding resolution. While the most popular one is mediation, we're going to hear a lot more about that this afternoon. My point earlier, there is a full range of non-binding approaches to conflict resolution. Advisory opinion, non-binding arbitration, mini-trial. The use of mini-trials in this city is certainly growing. Conciliation, confidential listening, others. These processes can be adapted, they can be modified to meet the particular demands of a conflict that you're involved in, and just an awareness that those process options are there can be very helpful to both you as counsel and to your clients. I want to say just a word about mediation at this juncture. Who here, by the way, has been involved in a mediation? Who's been to a mediation here? Okay. Are there any mediators in the group? Great. Okay. I hesitated to put this slide up, but I think just to make sure we're all on the same wavelength, reading from the same page. What is mediation? I'll tell you, I was in the office a few Saturdays ago, and business is getting better, right? I mean, I have to be in the office on Saturday. It was not always thus. But got a call about 10 o'clock on a Saturday morning, and someone sounded really in a dilemma, really a lot of anxiousness in their voice. And they really wanted to know a bit more about that transcendental mediation stuff that we do. And I took a couple of moments just to sort of straighten them out, and then started asking them what the problem was. Mediation, I think we're all aware, is the intervention into a dispute or negotiation of an acceptable, impartial, and neutral third party who has no decision-making authority, but who will assist contending parties to negotiate an acceptable settlement of issues in dispute voluntarily. Now, elements of that definition are changing as time goes on. The concept of mediator neutrality, for example. Is any mediator truly neutral? Particularly when we have mediators that are doing volumes of work for insurance companies or financial institutions. What about voluntarily? A number of U.S. jurisdictions have incorporated mandatory mediation into their civil justice system. Indeed, it looks like we may well be heading that way here in Ontario. Some would argue that we're there from a de facto point of view. But the principal notion is that a third party comes in who is acceptable to the parties in dispute and assists them in working something out. One of the challenges for those of you who may be required to access the services of mediators is understanding that there are different approaches to mediation, there are different styles to mediation. A few years ago we talked in terms of pure mediation, some concept that there was this pure mediation, and then other approaches were sort of deviating away from that. I think a fairer presentation is for us to understand that there is a full spectrum of approaches, from very evaluative approaches. Sometimes you hear it referred to as the head-banging approach to mediation, sometimes used in pre-trials and by former judges. At least that's the tag that they get. There at the other end of the spectrum is the facilitative approach to mediation. Sort of a fault, tell me more about that. How are you feeling about that? There is this spectrum of approach. I think effective mediators have an ability to move up and down that spectrum to meet the requirements of the clients and the disputants. But for you, it will be important to recognize that there are these different styles. And I think, Cinnie, you may have more to say about that a little bit later on. Other processes as we head up the stairway there, as we move from non-binding to binding on that stairway, one process to make you aware of is meet-arb. Again, a process whose popularity is growing. The concept is that the process starts as a mediation, and if the matter cannot be resolved, it flips into an arbitration, frequently with the same individual acting as mediator and then arbitrator. Are there challenges around that process? Absolutely. Is it being used? Yes, it is. There are safeguards. As long as there is awareness of the process and the pros and cons have been considered, it can be a very effective process. Arbitration, something that many of you will be familiar with. Quite often at our organization, we receive calls from parties in conflict and indeed from lawyers. When they think of ADR, they think of arbitration. That is the process. Arbitration, of course, is that next step up on our stairway. It is the binding process, typically. It is the process where now the parties have given up in terms of finding their own solution and turned it over to a third party or parties to find a solution for them. So you've crossed the Rubicon once you've gone over this stair. And at the very top of the stairway, litigation, the one that we're very familiar with. If we look at this stairway, and the reason we present it as a stairway, two principles, two thoughts to take away from this. One is thinking in terms of what's the right next step. When I'm advising clients who are in conflict, whatever that conflict may be, there may be litigation underway, we may be thinking about litigation, it may be at the very early stages of a relationship. What's the right next step? This stairway helps us remember that we have these steps and that there are a number of processes really on each of the steps. The other thing is that this is not an up escalator. It's not just sort of start at the bottom and work your way to the top, and once you're up there, you stay there. Again, one of the principles, one of the foundational principles in the use of ADR is that if we're at the very top, if we're using the litigation process, as oftentimes we have to, sometimes we have to get in there, apply for the injunction, get to court because we need to do that to preserve or create rights. But if we're on that top step, what opportunities do we have in the way that our practice is conducted, in the way that a file is managed, what opportunities do we have to come back down the stairway and try and resolve it on a lower step? And this puts us in mind of the reality. I mean, I practiced law for 15 years. I know how files are managed. There are peaks of activity in the life of any file. Discovery, or the pleadings to start with, of course, but discovery, pre-trials, preparation for trial, motions, these are where the peaks of activity are. Not much happens between those peaks. This reminds us that should we be building into the way we manage files opportunities, in other words, look at maybe discovery and mediation as something that goes in tandem. We get the information, then we mediate right away. Thinking about how we organize our files to access the appropriate stair in the management of any particular dispute. Finding opportunities to come down. I want to end with this thought, harken back to this new technology, and I want to leave you with a thought related to this. That ADR really does represent a new technology to more effectively manage conflict. I suggest to you that organizations, and in particular lawyers, who understand and use this full range of processes, use this new technology, are going to enjoy a significant reduction in the costs of conflict management. Of course, what that leaves unsaid is where do those cost savings come from? And one of the biggest concerns that are facing lawyers generally is that, yeah, that's great. Where's the cost saving coming from? Right here, out of my pocket. That there's a threat, that it represents lower incomes, that it represents fewer opportunities, and that furthermore it doesn't allow us to be effective at the things that we do know, rights-oriented approaches, litigation process, and so forth. And I suggest to you that this is the challenge. This is the challenge facing our profession in Ontario today. In many ways, it's the same challenge that faced smokestack industries a generation ago. How do we move from where we are now into an era where these technologies, this stairway, this full range, can be used, and can be used in a way that allows us to carry on our profession, carry on and earn a livelihood from it. Are there ways to do that? Darn right. I think in many ways it's an exciting challenge. We're going to have to look at things like, revisit things like value billing. We're going to have a hard look at hourly rates. We're going to have to look at that great mass of disputes and conflicts that are out there that right now people are just lumping it because they feel they have no viable or affordable access to justice. I think it's a time of great challenge and opportunity for the legal profession. Some of the principles that we've gone over here, I hope, will help you to understand what undergirds this whole ADR movement that seems to be everywhere today. I don't pretend to have all the answers around this, and I hope in what I've said I've stimulated some thinking and that planted some seeds that will assist you in more effectively representing your clients and conducting your practice. As I said, mediation has really proven to be the most effective process, and certainly, given recent pronouncements from the Attorney General, given things like the Canadian Bar Association report that was released in Vancouver this week, it is undoubtedly the process that you will be running into soonest and most often in the near future. For that reason, in this program focusing on sort of the basics or a primer approach to ADR, we wanted to put the spotlight particularly on mediation. We felt that a way to do that very effectively was to show you a short video. It's entitled Mediation, an Introduction, and it really demonstrates this process and talks about its strengths, talks about when it's appropriate, and allows you to see a particular application. In this video, it's an environmental dispute, but the principles, I'm sure you can see, will be applicable to a wide variety of conflicts. I should say, and Don's just reaching for the video here, when you've arrived, I think each of you has received a video in your package. I want to point out, not to confuse you, the video that you're about to see is not this video. The video that you've received in your package is a copy of a previous Law Society program called Mastering Mediation, which goes into a considerable greater depth in the mediation process. And I thought it was a tremendous bonus on the part of the Law Society to make that available to participants here today. But I do want to underline, that is not the video that you will be seeing. The video that you will be seeing is available for purchase, not here, but the producers of that, and I hasten to add, none of us are financially associated with the producers of it, but some lawyers have found this video helpful. It's about 17 minutes, and they found it helpful to show to their clients to help explain the process as well. If anyone is interested in acquiring a copy of this, there is the usual special discount. I feel like I'm at the CNE, but today and today only. But there are certificates here if anyone is interested in that. And so with that, I'm wondering if I can ask our fellow in the control booth there, of sorts, that looked at some of the principal issues that are kind of swirling around ADR at the present time. Don Short's going to speak in a couple of moments about the resistance that is there to using ADR, the resistance that lawyers have, the resistance that our clients have, and some ways that we might go about breaking down that resistance. Justice Benotto is going to speak about the dispute resolution officers and the use of mediation and ADR approaches in the family law context. Cinnie Noble will be speaking about choosing a mediator. As I said earlier, that's something that each of you will be having to ponder as time goes on. And so what are the factors in terms of choosing a mediator? And finally, Michael Silver is going to be speaking about effective client representation. What is the difference in terms of representing clients in an ADR process, and particularly mediation, between that and the usual factors in representing a client in litigation? So each of our speakers is going to take about 10 minutes. We will have time for question and answer towards the end of the session, and as I said, our speakers will be hanging around a little bit for any specific inquiries. But with that, Don, I wonder if I could ask you to help us deconstruct the resistance.
Well, I'm going to try. Never follow an animal actor, R.H. Thompson. This overhead is based on something that CCH put out in the last little while. It's the standard image of, or at least the justice overburdened by time and money. And that is the argument that is made for why ADR is necessary. The first pitch that seems to be made is it's going to result in faster results, more economically for the client. One of the problems that those of you in this room have, and we all do, I share it, I'm a civil litigator. I got involved in this process about 3 years ago when Chief Justice Callahan proposed the ADR Center and said we need to have a pilot project, and they asked me to go on the team to develop the center. I said, but I know nothing about this, and they said that's your main qualification. They wanted to have someone who was a civil litigator who was not sold on ADR, and I was the prime candidate. I tell you now that I am sold on it, having seen the process. 3 years ago, if we'd asked this room how many people had participated in a mediation, I don't think a hand would have gone up. The last 3 years, the move to ADR, the move to alternates to dispute resolution, the move to alternatives to the traditional long drawn-out trial process is probably second only to the internet in terms of the amount of movement and change that's taken place. And I'm on a Thursday, if you'd asked, well, I guessed when this program was put together, on a Thursday night, the last weekend in August at 5 o'clock at night, how many people do you expect? I mean, I thank you all for coming, and I still scratch my head to say, you know, it says something about how important this is going to be to our profession. Rick thinks about a stairway to heaven. I think in little boxes, a different generation perhaps. My materials, talk about alternate dispute resolution, they got shuffled through no one's fault, so disregard the order, and the only page that really matters is the first one, and that's what's on the board here. This is Rick's stairway in a more linear fashion, but it talks about unassisted negotiation, moving forward to facilitated in a various number of formats, and all non-binding on the left-hand side, and then as you move across, you get into arbitration or traditional. Arbitration being, again, one advantage to being able to control the process. And really, that's the most important message, I think, that you need to take away from today, is that the process is as flexible as you want to make it. And one of the newest jobs in creation is what Rick does. And he's not alone, but dispute resolution process creators, that's, I don't know what the right buzzword is, jargon is not me, but that's what your clients are looking for. They are looking for people who will come into their company and say, how can we minimize disputes? How can we come up with a process internally that's going to avoid problems with our suppliers, problems with our customers, and problems within the organization? And there's money to be made doing that. And there is also, you know, a service to be provided to your clients doing that. And it's either, whether it's with your client or with the dispute that you've got. If you've got a file that, when you think about how are we ever going to possibly try this case, it's got too many issues, it's got too many parties. If you go to a process creator and say, help me to come up with a method where we can mini-trial some issues, where we can mediate some issues, where we can determine what we need to have a judge do. The judges at the commercial list are great at this. If you narrow it down enough, they'll give you an afternoon to decide that narrow issue. And it saves years of waiting for the trial. The best selling point from my point of view for the ADR Center is the stats. There are about 17,000 cases went through, 2,977 got mediated. If I'd asked you 2 years ago what percentage would have resulted in a solution, I don't think you would have guessed that if you take the yellow and gray bars, 23% didn't settle of the ones that went to the ADR Center. 28% did, which if you look at that, that's more than 50% of the cases that came in for mediation actually settled at the center. Another 18% settled before it got there, because one of the rules of the ADR Center is you've got to go out and try and meet beforehand. People settled the case before they even got to mediation. That means that only 32% opted out altogether. So 32 and 23% of the total cases in the inventory, about 55%, those ones didn't result in a result. But that means another 45% of the cases settled before discovery. Now, from a client's point of view, and if you get that word out, that's an awfully effective statistic, because that means 45% of the cases that come in the front door you can settle in a hurry. I say we've got to look at value billing. We've got to consider that as an option. We've got to try and move the profession to say to the client, if I save you a heck of a lot of money by mediating it and coming to a solution at an early stage, that's got to be worth something to you. And we can't look straight at hourly rates because, frankly, it's not in our interest. There's no one here from the outside, is there? The task force resulted in a pilot project that was to be 2 years in length. And Christine Hart was the director, and she did a super job along with her team of dispute resolution officers. Christine has now retired from that job and tells me last night that she has now become a partner at KPMG, the accounting firm, who recognize that ADR is important. It's important to their clients, it's important to their industry, and they're trying to get a foothold in this particular area, having Christine lead a mediation and a dispute resolution creativity consulting organization. So what I'm saying to you is, I'm glad you're here tonight. You gotta be wary, because this is not the lawyer's turf alone anymore. That's an issue that we need to address, and you need to be aware of it. One of the important issues that is going to be coming in the next 2 years in this field is qualifications. Right now, I can put I'm a chartered mediator on my card, because nobody charters mediators. Right? There are lots of skilled people out there, lots of people selling courses. Here you are tonight. You can now go back and say to you, I'm trained as a mediator. All right? Because, hey, I got the slides. Right? Oh, is that 5? Oh, I've got 5. All right. Well, that means I've got to start talking very fast, read the slides as I talk. There was no significant dissatisfaction. 17% of the people only 17% thought that doing it before discoveries was a problem. That means that it's an early stage, it's before paper. There's been settlements across all types of cases. We thought that it would be great for wrongful dismissal and perhaps personal injury cases, that kind of thing, but otherwise it wouldn't work. In fact, we found a broad range. It works. The people who came, 96% of the lawyers and 95% of the parties would definitely come back. That says something. More than 70, well, it does. This is important from the lawyer's point of view and the client's point of view. More than 70% of the lawyers and 75% of the parties believe their cases would have settled at a higher cost if it hadn't been referred to the ADR Center. So the satisfaction, your client going away with a smile on their face thinking they've saved money and got a better result, 75% thought that. Look at this one. When I asked to estimate their cost savings, less than $50,000 was most, but 7% of those who came said they saved more than $50,000 in legals, and 14% estimated the savings at over $100,000 to the client in legals. Now, that person who filled the questionnaire in had to be crying, but but that's the kind of savings that if we can get the message out there that this. One of the reasons people aren't coming in your front door now, I was looking at the phone book today, the Yellow Pages, lots of huge pictures. Go and look at it sometime if you don't advertise in the Yellow Page and see what the competition's doing. Nowhere does it say, we mediate your disputes quickly and get you a good solution. It says damages, we're out there to, it's the adversarial system. But it's the kind of thing that I think if the public knew that they could get a result within 3 months of coming in your front door, 45% of the time, more of them would come through the front door. And that's where we're going to have to change the mindset. And you, frankly, have got a leg up because you're here tonight. Let me move very quickly to something called CEDAR, which is the Center for Dispute Resolution in London, England. It's been out there for about 5 years, I think. And they're ahead of us just a tad, but the 3 elements that they see is dispute management, dispute prevention, and dispute resolution. Dispute management is the kind of thing we're talking about. How do we manage the dispute? There's a field that we can get more involved in if you identify it and start doing a little bit of... 850 cases came in with 1.5 billion pounds value in England, in this place, and they settled over 150 million pounds worth of cases. 90% of the cases settled during the mediation had previously been in a deadlock. In 1994, the average cost savings were $44,000 and up to £1 million in an individual major case. It's been used by all sorts of levels of government, and again, the real pitch that I'm trying to say is industry associations, your clients, they have heard about this, they like it, they want it, and you've got to be able to provide it to them or they're going to get it somewhere else. CEDAR says their aim is to deepen the legal profession's familiarity and regard for ADR as a practice tool. And I say to you, it's a tool. Traditional litigation is still there. I had one partner who said, why would I ever take a winning case to mediation? Because I can win this one at trial and get my client 100 cents in the dollar. I said, well, maybe you'll collect it, maybe you won't. Maybe they'll still be in business when you tell them to collect. That person 6 months ago said, no, I'm going to avoid mediation like the plague. 2 weeks ago, he called me and said, how do I join the American Bar Association's ADR section? You know, he's, in the last 6 months, he's heard it too many times from his client. He needs now to know what's going on because we can't put our head in the sand. We have to recognize that we're beyond merely promoting ADR. We've got to look at the practical ways of coming at it, see what works, and recognize that it's going to be part of the mainstream in the legal, business, and public sector practice. And the theory is that when all that happens, we'll have saved some time, saved some money, and justice will have a broad smile. I recommend to you the bibliography in the back of your book and the terms there. That tells you what the real words mean. I thank you for your attention, and I'm done.
Thank you, Don, and I know you've given us some ideas that can help us tear down that resistance. Is Justice Benotto here? Oh, hello. What about ADR and the courts? I can tell you from our own experience that interest is growing there. We certainly have, our organization has conducted trainings for the National Judicial Institute, helping judges incorporate interest-based negotiation and some of the mediation techniques into what they do in case management, pre-trial settlement conferences. We thought it was important in this session to let you know something that's happening right here in our city. And Justice Benotto, welcome. And I know that they're looking forward to hearing what's going on with the DROs.
Thank you. Well, I'm here to tell you a little bit about this project that's been going on in the Family Law Bar for the last 15 months. It's interesting really for two reasons. One is that it confirms what those who practice family law instinctively knew, and that is that people really want to settle. The second thing that's interesting about it is that it challenged some of the preconceived notions and some of the assumptions we have about mediation, and that is that the term mandatory mediation is a contradiction in terms, because part of our project involved requiring people to attend before a mediator. And the results, which I'll tell you about in a minute, were really quite staggering. But first, let me tell you a bit about the project itself. It started in May of 1995 when the Bench Bar Committee, the Family Law Bench Bar Committee, assembled a group of about 32 experienced family lawyers. These were, unlike the civil bar, entirely volunteer. And that's part of the reason I don't have any flashy color slides to show you. The project was initially supposed to be only for 3 months. The project was set up in part to offer people mediation services right in the courtroom. The reason that we had done that was as we moved towards a full case management system in family law, we found that the judge's time available for having case conferences, which were really settlement discussions, grew more and more scarce. So we thought if we called upon some practitioners to volunteer their services, we could offer that same service virtually on demand 5 days a week. And the response was absolutely phenomenal. People have been using this process on a voluntary basis, and it has been so good that we can't stop it. The 3 months has now grown to 15 months, and the very thought of closing this down sort of petrifies everyone. So we have now been looking at some way of establishing a structure that can be put in place to compensate the people that are doing this. The panel has grown and now consists of about 48 people. I might be out by one or two, all of whom donate about a day and a half of their time per month. The other interesting part about it was that in addition to offering free mediation, we also required people in certain kinds of court processes to have their first appearance not before a judge, but before a dispute resolution officer. This really was the mandatory part of the whole mediation process. And the people who put the project together thought that this would be an absolute disaster, that people would stomp out. They would say, I'm here to see a judge. The reason I started an application was to get in front of a court. If I wanted to hire this person, I would have done so. This is ridiculous. In fact, we found that the settlement rate at that first meeting turned out to be almost 80% of cases settled at that first meeting. In part, we found that the people that turned up were so happy to have someone who had read their material and talked to them and took them in and really focused on the case and on their case. And after about the first nanosecond, they didn't care that the person wasn't a judge. They didn't care that the person couldn't make an order. They wanted a chance to tell their story. Now, granted, the kind of case that we made this mandatory process occur in was a very restricted kind of case where you're asking for a variation of an existing judgment. So the issues were somewhat more narrow, and it really lended itself to being able to be settled at one sitting. We're now looking towards establishing that same system next spring when we have the child support guidelines come into effect, and we're expecting an absolute avalanche of applications. So that is really a summary of what happens through the DRO process. The settlement rate on the voluntary aspect, that is the mediation, the case conferences, is not quite as staggering. It's about in the low 70s, around 72% of cases resolve, but that still is quite spectacular in our view. So that's it.
Thank you very much. That's been quite helpful, Your Honor. Some will have noticed me flinch ever so slightly when you said free mediation. To paraphrase Mr. Justice Walsh, I think the disputes are disputing in vain, but in many cases, there will be a choice of mediator. It will be a truly voluntary step that's taken in a dispute. And we thought it would be worthwhile to focus for a few minutes today on factors that you'll want to consider in selecting a mediator when in fact you have that choice. And we're very fortunate today to have Cinnie Noble, a well-known mediator and lawyer in this city, an author, with us to talk about this issue, choosing a mediator. I was reminded before our session as well, and I don't think it appears on your bio material, but Cinnie is as well a member of the Order of Canada for the work that she's done with the handicapped. So Cinnie, it's a pleasure to have you here today. What should we be looking for when selecting a mediator?
Thank you. And thank you for the opportunity to speak about the subject that I think is a really major one. And I'm speaking to you both as a mediator who has been chosen to mediate cases and as a lawyer who has been involved in the selection process. When I started mediating, which was just about 4 years ago, the types of questions I used to be asked were things like, well, how much is your fee and when can you start? And I'm glad to say that counsel and parties are becoming increasingly more knowledgeable about mediation and the types of things you should be thinking about when you're choosing a mediator. And I'm going to give you a little example of what happened just last week. I had a call from a lawyer who asked if I would mediate, was available to mediate a family law case. And in addition to asking what my fees were and when could I start, he also asked a series of questions which I think are important, and I'm going to share them with you. He asked, how long have I been practicing mediation? When was I trained? Was I trained in family law mediation? Where was I trained? Whom could he call for references about my mediation work? Do I have a mediation agreement that I have a contract to mediate? And if so, what are the provisions in that? Do I generally favor joint custody? He also asked whether or not I represent mostly women in my law practice. He asked whether or not I screen for power imbalances. And he said, if I do screen for power imbalances and find that in fact there is some unequal bargaining power, do I still mediate? And then he asked whether counsel attend at the mediation sessions. I thought those were really good questions and really indicated that people were putting their heads, at least this particular lawyer anyway, was putting his head around the kinds of variables one should think about when choosing a mediator. I do want to add that one thing that he didn't do, which I think is really important as well, is he didn't engage me in any conversation about the case, the merits of the case, who he represented. Simply wanted the facts and wanted information from me. Asked for my CV to be sent out and if I had any other promotional material. I am pleased that counsel are making these types of inquiries, and I think that if you're representing clients in ADR, that you should think really seriously about this, and it reflects a number of things. One is that counsel need to understand the mediation process. They need to understand the whole idea of what the mediator does, what the role of the mediator is, and to respect that people, the clients, do want to participate in the resolution of their own disputes. And how you can facilitate that, to me, is a sign of your advocacy skills. And more, lawyers need to be adapting their advocacy skills to this kind of forum. In my paper, which is at C, I have listed a lot of factors that I think are important to consider, and I'm just going to highlight them. You can read that at your leisure. I'm going to highlight some of them at this point. What I will start by saying is I think it's really important to include your clients in all of the steps about choosing the mediator. But always keep in mind that you need to persuade the other side and the other party of why you're choosing it as well, the particular mediator or mediators that you're going to offer as suggestions. One of the big areas that people look at is, does the mediator require the substantive knowledge in the area of law? In interest-based negotiations and mediation, I, generally speaking, don't think that is necessary, but many people think it is. In the case that this lawyer called me about the family law case, he knew that I practiced family law and had said so during the course of that conversation, and that was important. However, it might not be in every area, and you have to remember that there are lots of mediators that aren't lawyers, who are accountants. We were talking about this just earlier. Actuaries, different people in different professions are taking on the role and understanding the concept of interest-based negotiations. But you need to decide that for yourself, how important it is. If you are going to be involved on an ongoing basis, attending mediation, providing independent legal advice, then you may be less concerned about the idea of that person who's the facilitator being an expert. Rick mentioned earlier about different types of mediation. I have referred to several in my paper, including facilitative, problem-solving, transformative, facilitative mediation. There are different types, and people call them different names. I'm going to refer to one, for instance, problem-solving mediation. In problem-solving mediation, the mediator is highly active, very task-oriented, gets the people to the table to look at what their interests are, identifying what they see as the problems, helping them generate options, and generally being quite active in the whole process. Feelings and emotions might not be as primary for the problem-solving mediator as they are in other areas like therapeutic mediation or strategic mediation. To me, these are titles that you can give to the types of mediation they are, and it might be worth saying to a mediator, what type of mediation do you practice? Some of us will focus on feelings and emotions because we think that it's important. I recently did a mediation that was actually with two CEOs. It was a contract dispute, and these two people were really upset about the fact that their relationship was breaking down. It had been ongoing for many years, and they wanted to deal with how they felt and what they were going to do about it. So there are certainly cases where those emotions cannot be ignored. But it's really, I think, relevant to ask somebody, what do you do? What kind of mediation do you do? Whether counsel attend mediation. That's an important factor that you need to ask the mediator. Some mediators have policies where the lawyers simply don't attend. It's common in a lot of family law cases, for instance, but in other cases as well. I've done sexual harassment issues, for instance, and it really depends on the parties and the type of mediation someone practices. In doing a cost analysis with your client, you have to consider whether or not paying for their lawyer to attend as well as sharing the cost of the mediator, whether this is something that's necessary. And there might be reasons why you need to attend. For instance, if you do have parties that have unequal bargaining power, you're representing somebody who is vulnerable, who doesn't negotiate very well, feels intimidated by the other disputant, then it might be appropriate to say to the mediator, that might not be your usual policy, but do you have any problem with me attending? And that could be a factor in your choice, whether or not that's the person who you want to go to or you want to recommend. It's probably trite to say that you should look at a mediator's neutrality, but mediators should be, and mostly are scrupulous about being a neutral party. But there are cases and situations where people might doubt that. For instance, that person who asked me if I have a bias for joint custody. There are people who are known for doing that they simply have an inclination. So it's important to find out and ask directly. It's really appropriate to do that. Also, you often get referrals from colleagues, so it's appropriate to say to someone, do you know if they show any kind of bias? And other things where there might be an apprehension of bias could be in situations where people are sharing space with other people, where one of the lawyers represented somebody, or the mediator represented somebody in a previous situation. You need to check those things out. Do you know the person? Have you worked with them? Do you know them as a friend? I think it was Dawn that mentioned earlier about training. There are no qualifications for people who are in training and education at this time, and hopefully there will be, because we need some kind of standard. However, it's appropriate, as far as I'm concerned, to ask about someone's training, where they got it, when they got it, what experience they have. Things such as asking questions about how many cases have you mediated in the past year, and have you mediated this type of case? What referral sources can you provide? Perfectly good. What is your education? What is your background? Do you practice interest-based mediation? I think it's also important to consider such things as gender. Many people, you might be representing somebody who really feels quite strongly that a person who is a white-faced person won't understand that dispute as well as somebody who is of their culture. So you go on a search to do that, or they go on a search to do that. And there are cases where that might even mean co-mediation, where the interest-based mediator brings in somebody of that culture. Mediators generally can be flexible about this and look at that. Gender could be an issue, race, always considerations. You need to be consulting your client about it and seeing what's important to them. The mediator's flexibility around hours. One thing that Court Annexed mediation doesn't provide so much as, and I don't believe can, is evenings, weekends, finding out if they mediate in half days, full days, whether they do 5 weeks of an hour and a half each. Find out the kind of information and how flexible they'll be about it. And similarly, their accessibility, are they available now? When are they taking their vacations? What kind of commitment they can give to the case, and will they be readily available? And of course, there's those very basic factors about location and parking and accessibility for people with disabilities, washrooms. So there are those kinds of basic factors as well. I'll mention one other characteristic that I think is important, or one other factor that is important to a lot of people, is the personality of the mediator. You often hear when people are describing a mediator, people using other characteristics about them. It might be bright, fair-minded, reasonable, creative, able to engage in active listening, other kinds of personality characteristics. I always think it's important to ask the clients to make a contact with the mediator, the prospective mediators, and ask a variety of questions, again, without engaging them in conversation about the merits of the case, but people will get a sense of what they feel about that mediator, and that's an instinctive thing, but it's not unimportant. Now, how do you find people? There are all kinds of places to find mediators. Some of it is from our colleagues. There are professional organizations, mediation associations. The Canadian Bar Association has an ADR directory with names which you can use as a starting point to make the kinds of inquiries we talk about. I always think it's important to get about 3 names of people, having interviewed, get information about them, and being able to pass on to the other side why you're choosing them, here's some information about them, and to be able to share whether or not you think the person should have what kind of mediation that you think is important for that particular case. Sometimes arranging a conference call is a good idea as well with the mediator to check them out and to find out just what they do, what their pre-preparation is for the mediation. I think that the summary of mediators is a really serious and important issue, and one that a good advocate does need to get their head around. It's a chance for you to work with your client around how are you going to approach mediation, what do you need to know about it, what the process is about. And I think that if you are able to reach agreement with the other side and the other party about who the mediator is, that hopefully that is an indication of at least one decision you're able to reach together. Thank you.
Thanks, Cinnie. That's extremely helpful. All right. You're going to mediation. You're preparing for that mediation, and you're asking yourself, what ought I to be doing to be as effective as I can in this process? What does effective mean in mediation? We're very fortunate this afternoon to have someone that I don't know that there's anyone in this city better able to comment on this question. Probably one of the most experienced mediators in Ontario, Michael Silver. Michael has been a full-time mediator at the ADR Centre, has mediated, I'm sure, hundreds of cases, and has seen firsthand what works and what doesn't. And we thought that it would be appropriate to have Michael speak to us about effective client representation in mediation. Michael?
Thank you, Rick. Can you hear me, by the way? No. How about now? Is that okay? Effective client representation at a mediation, in my view, does require counsel to assess the risks of the litigation and to scrutinize the alternatives to a settlement with your client. Likely this will also entail a review of the costs that are going to be involved in the litigation, either by winning or by losing the case, and an extrapolation of the litigation process and what that will mean in terms of your client's life or their business or other interests. Really, as counsel for a client at a mediation, one is forced to delve into the nuts and bolts of why the client is involved in that litigation and what they can realistically hope to get out of it. The business and the personal ramifications are interests that have to be thoroughly examined and prioritized. In my view, effective representation means encouraging a client to settle when they've reached the high water mark of what the litigation can do for them. To not settle and to litigate beyond that point effectively locks the client into, at best, diminishing marginal returns, or at worst, actually moving backwards. The first question to answer is your case even suitable for mediation? And not every case is. But our experience at the ADR Centre is that it is almost always appropriate. Underline the word almost. At the Centre, we've seen virtually every kind of case settle. Everything from acrimonious shareholder disputes, partner disputes, incest cases, assaults, environmental cases, complex multi-party commercial disputes, medical malpractice, you name it. Those kinds of cases have settled. So it's really not possible to rule out a case simply because of the subject matter or the amount of money in issue or the number of parties. However, I think Einstein put it best when he said that negotiations are desirable when there's a genuine desire to solve a problem and an unpalatable alternative. In my view, a lawyer's job when representing a client at a mediation is to help the client explore the settlement options in terms of solving the problem and assessing the alternatives of not doing so. In terms of what should be done prior to the mediation, if you select mediation, there's a number of considerations. Mediations do tend to work best in a kind of structured informality. So you want to select a comfortable forum and venue for the session. Ideally, there should be rooms available for joint sessions and separate rooms where you can retire with your client and meet with him or her privately and with the mediator. It's absolutely imperative that you bring the client or representative of the client with full authority to settle. Full authority means having a wide range of discretion to decide upon all kinds of money and non-monetary options. You should also bring the person that has actual knowledge of the events in issue. They may not be the same person as the one with full authority to settle in that case. In my view, it's not productive to attend the mediation by yourself or to bring someone who doesn't have the authority or the knowledge. Experience has demonstrated that it just doesn't lead to workable results. And although it's possible to settle a case without someone with full authority, it makes it very much more difficult. I had a case today where the party with authority was in California, and it was very easy for them just to nix the deal, not being present, not being able to hear the other side, assess them as a witness, and it may be that we're going to have a session with that person here in Toronto. In my view, failing to bring a person with the right authority when the other side does so may actually be unproductive. You may actually poison the atmosphere for settlement and create a whole issue as to cost that you don't really want to get into. In the final analysis, settlements only happen if the parties want them to. The best that the mediator can do, and all that the mediator really can do, is tap the genetic potential for a settlement, tap the settlement DNA, so to speak. But it is true, and I think I can improve on Don's statistics actually. Some were released last week, and the settlement rate at the center is closer to 60%. So assuming that that's so, this means that your client is more likely than not to get something really positive out of the process. And therefore, it probably makes sense to give that process a chance by facilitating it and bringing the right person with full authority. It's probably advisable to sign a confidentiality agreement, settlement negotiation privilege notwithstanding. You don't want anything used against your client later in that proceeding or in another proceeding. You should probably exchange all relevant materials. This means damage scenarios and breakdowns, expert reports, valuations, productions, whatever it is that's going to be important, and probably exchange statements of your party's best case. That will help put the other side in the picture, help clarify your own thinking, and also help put the mediator in the picture. It's very important to prepare. Know your client's case inside and out, and try and get inside their head and appreciate what might be important to them. You should have those discussions ahead of time and try and formulate some settlement proposals ahead of time. What you don't want to get trapped into is letting the mediator do all the work. We're quite willing to do that, but it probably isn't going to work best for you. One of the problems is that if you let the mediator do all the work, and speaking frankly, you may convey the impression, at least to the mediator, that you want the mediation to be terminated, and you might get your wish, and that might not be in your client's interests. Remember who you're persuading at the mediation. The point is you're trying to persuade the other side. It's not the mediator you have to convince, it's the other party, and it might help to think of them as your jury. It also may be very important to let your client express their feelings, let them vent. It's a very important human need. Some of the panelists have discussed the importance of interest-based bargaining and abandoning positional bargaining. Very, very important. The bottom line is your client is in litigation because they are involved in some kind of a dysfunctional situation, or they wouldn't be there. And they have, by definition, failed to resolve the matter on their own. So if you just reiterate the old positions that may have been taken before the litigation or at the outset of the litigation, you're likely not to get very far. Another quote from Einstein is that we cannot hope to solve our problems with the same level of thinking we used when we created them. And of all the quotes, I think that best describes the mediation process. You need to get into a new level of thinking, a resolution-oriented kind of thinking. In terms of what to expect in a mediation, likely the mediator will begin with some introductory remarks. And if you feel that you're not ready to go, that you need more time to produce what you need to have ready or to get material from the other side, don't be afraid to ask for an adjournment. I know it's not written in any official policy, but I can tell you that certainly at the center, if the reasons are sound, an adjournment likely will be given. And it may allow you to prepare a little more and make the future session more productive. Usually at the beginning, the parties set out their positions. It's called a joint session. Each side basically tells their story. And then usually the parties break into separate rooms and the mediator shuttles back and forth and canvasses options for settlement. During those separate sessions, it's common for the mediator to do a risk assessment with the party. And really, it's part of a mediator's job to conduct that risk assessment, and in so doing, look at the alternatives that each side has to an agreement. At the center, the staff mediators have seen hundreds and hundreds of cases of all types. So you can use that to your advantage. Bounce some propositions off those people. See what they think of what you're saying. Let the mediator ask probing and difficult questions. And frankly, attempt to answer them in an objective way. If you or your client can't answer them in an objective way, then that might flag to you that you've got a problem in your case that should be considered in terms of your decision making. Now, the mediator can't do all the risk assessment alone. It's helpful to have the lawyer really give their client the opinion on what they really think of the case. And many clients look to their lawyers to do that. So I would encourage that. Inventing options, brainstorming, is something that you'll likely get into. Remember, the mediator has only been familiar with the case for a couple of hours. Your client probably knows it inside out. Let your client be involved in that process, and you'll probably get some better options generated. One of the things a mediator can be helpful with is encountering reactive devaluation. And that's where basically the other side is discounting anything you say simply because you said it. If you make an offer, they're thinking, oh, they've offered here, that means they can really go way up here. And you get into a very time-consuming negotiation when that starts to occur. So a mediator can help you by floating proposals. Don't be afraid to suggest to the mediator that they float a proposal, or ask the mediator to create a proposal and then start to work on it with each side. One of the things you don't want to do, though, is if the mediator floats a proposal and asks whether you would accept it, don't reject it if you think it's going to be workable. Because if you reject it, it's unlikely the mediator will fly with that, and you may be ruling out something. So don't bargain with the mediator. Bargain with the other side, but not with the mediator. What should you do if the other side's completely unreasonable? Well, don't get mad. Suspend your natural reaction. Buy yourself some time. Ask for a break. Ask for an adjournment. Slow down the negotiation and keep sight of your real interests. Ask open-ended questions. One technique that's useful is use silence. Ask a question and then pause, and don't interject a comment, because you'll let the other side struggle to resolve the question, and usually people feel compelled to break the silence by answering the question. Build bridges. Offer the other side something. Remember, you make peace with your enemies, not with your friends. You may have to hold your nose a little bit doing it, but chances are, if you can develop a proposal that is essentially of low cost to you but high value to them, that's going to start moving you forward. Apologize if useful. The power of apology cannot be underestimated. It can go miles in reducing tension and facilitating a settlement. Finally, don't be afraid to develop your client's best alternatives to an agreement, and essentially to worsen the other side's worst alternatives to an agreement. You may have already done that by bringing a motion or taking some other step in the litigation or taking some business move, but that is a legitimate, as long as the steps are lawful, a legitimate bargaining strategy. In conclusion, don't forget that you are there as your client's advocate. And as such, you shouldn't stop advocating. But it's just that advocating in the context of a mediation and in the context of interest-based bargaining may mean a very different kind of persuasion and a compromise making that may not be in accordance with the merits necessarily, but will maximize your client's interests and get a better client result. Most clients do not enter litigation because they want a good litigation result. They're interested in having the dispute resolved and in a good client outcome. So keep your eyes on the prize, maximizing what the litigation can realistically do for your client. There's really no better way to represent your client than by doing that. Thank you.
Thank you, Michael. I think all of us in the planning and the presentation of this program were concerned that by the time we got to 7 o'clock, there would be some Migo effect. Migo, my eyes glaze over. As I've looked around the room, while each panelist spoke, I detected no Migo effect. This is something that obviously you have some real interest in. In accordance with our undertaking, we're going to have you out of here by 7 o'clock, and in a moment I'm going to open it up to questions that you may have of any of the panelists. Just before I do that, 3 brief points. One is that in terms of encouraging clients and making sure that clients understand that this isn't some kind of off-the-wall approach, we have found that the recent Bencher Bulletin that deals with the amendment to the rules of professional conduct relating to ADR is helpful to review that with clients, and for that reason we put it in your material. It's the second last page in the manual, and so we just point out that that is there. Secondly, there is an excellent paper in the material by Marvin Huberman talking about the use of ADR approaches in pretrial settlement conferences. The principles in that paper and the detail in that paper extends beyond just that context, and I very much recommend that for your attention. And finally, touching on a point that Michael mentioned in terms of cases that are suitable for mediation, we found that many counsel feel at sea in terms of, is this the right case for mediation? Of course, we think the question should be, why isn't this case going to mediation? But a tool that counsel has found helpful is a mediation suitability checklist, a very quick checklist that you would work through with your client to determine whether mediation is indicated in a particular dispute, and that's in at page A15 of your materials. We're open for questions, concerns, points that people would like to make. Yes?
May I put 2 questions to you, please? Firstly, it seems to me that when you're mediating, as a mediator, you're perceived as an authority figure by the parties. What do you do when the parties ask you what your recommendation is? Where the party says, well, what do you think I should do? Then now that's not really your function. How do you avoid it? How do you deal with that? And after that, well, maybe I'll put the second question to you as well. How do you avoid, as a mediator, the stigma that you're merely there to split the difference?
Good. 2 good questions, and I'll repeat them for the benefit of the taping. The first question is that you're clothed with some authority or being an authority figure as a mediator. What do you do when parties turn to you and say, what should I do? What do you recommend I do? Is that really any part of your role as a mediator? And secondly, what about the concern that comes up, mediators that have the stigma attached that they say, just split the difference. Come on, that's my job, just split the difference. Very real concerns for mediators. I'm looking down my row of panelists here. Cinnie or Michael, would you like to start off responding to either one or both of those questions?
I think they're good questions as well. There is a type of mediation that I referred to earlier, evaluative mediation, where in fact that's what mediators say they do. They'll give you an idea of what they think, an opinion. I don't do that, and if people ask for my opinion, I ask them to go to their counsel to think about it and to talk to the counsel about it. I usually will say to somebody, well, what is it that you would like? What is the outcome that you would like to see? But I don't give an opinion at all about it. Do you want to ask?
Sure. I think it does have a lot to do with the mediator's style, and some are more evaluative than others. I don't, or very rarely, give an opinion, even if asked. What I may do is continue to ask questions that basically get them to reach their own conclusion about it. I'll ask some difficult questions, like, what do you think of the fact that all the other side's evidence is uncontroverted? Or, questions like that. And that generally does the trick.
But Michael, I think it's important, again, we're back to the terms in this art or in this industry can mean whatever you want them to mean. There is no doubt that there are, shall we say, retired members of the judicial community who think they are running a pretrial when they conduct a mediation. That's their view of what a mediation is. And in the right case, that's what you want. You want an indication of where I'm going that may be not binding, but at least I can now go back and say to my client, well, you see, I told you, but now you've got somebody with a little clothes with some past judicial authority, and they said so too, so let's settle. But that's a very different, that's rights-based in capital letters. That's somebody saying, this is what the law is going to be, and that's how we're going to decide this case down the road. It's got very little to do with interest-based. And that's why we're back to your point. Ask what kind of a mediation I'm going to get. Because, and talk about power, counsel, if the other side doesn't know to ask that magic question, and you've got a loser on the law, I mean, the limitation period ran out when the action was started. All right, but the poor person suffered all those injuries. Which kind of mediator do you want? Yeah, sorry. Was there a second half?
Well, I just wanted to chip in on the comments you've made. I think that we've covered it largely, but I think that that spectrum and knowing that you have a choice, that some mediators do have substantive knowledge, and that's why in particular mediations they may be able to be helpful. I think it's got to be very clear that the mediator is not there proffering legal advice, but in some cases a mediator's view on that, particularly in caucus, can be helpful in moving things forward. The split the difference comment, I think, is interesting, and while as mediators we never think of ourselves that way, let's just get out the sword and cut the baby in half, I can tell you in all honesty that in the late stages of mediation sometimes the parties welcome that kind of suggestion, and in an appropriate case I think a mediator has to have sensitivity to know when that may be helpful. It's not what I think of as mediation being all about, but in some cases it can be helpful. The question here?
My clients would ask me, and that is, how much will it cost?
Good question. Of course, the answer is it depends. Commercial media, first of all, it might cost nothing if you're having it done in certain forums.
Not any longer.
If the center continues.
I think those days are numbered. For commercial mediators, our organization and others like ours, it is not unusual to expect to pay something in the range of $2,000 a day for a mediation. The cost is usually split between the parties. In other more complex matters, an hourly rate is sometimes indicated. Mediators' fees from it's the same as legal fees. For example, my hourly rate is $300 for commercial mediation work. But it does vary on the nature of the dispute, the time involved, and so forth. But does that go some way in answering that?
I think the other issue, though, is there are an awful lot of wannabes out there, and there are a lot of people who have taken the courses and are trying to build up their inventory so that when the question is asked, how many of these have you done, they'll be able to answer more than one. And those people, depending on the nature of your case, there are bargains to be had. Sometimes you get what you pay for.
Yes, over here.
Some difficulty in choosing a mediator. The client says, how do you know that this lawyer, who is now a mediator, yesterday she was a lawyer, wasn't a friend of the other lawyer, and I'm not going to get a fair shake? I find that often constant, and I don't know how to answer that.
Good question. Concerns about when selecting a mediator, knowing that there is really impartiality, that there's no connection that might not be apparent. Don, do you have a comment on that?
Let me tell you that sort of, again, I'm the guy who sort of, for whatever reason, lucked into being a step ahead, but only because I was there. I got asked to be on the board of something called the Canadian Foundation for Dispute Resolution. This was an organization founded in Alberta primarily by the oil companies originally because they found they got stung in the oil sands problems with judges who didn't understand their industry. And so they said, look, what we need to have are people who are knowledgeable, who we can go to in a pool and know that they're not biased, have a way of getting some affidavits from them or otherwise about their neutrality, and yet somebody who someone else has vetted. And so what the Canadian Foundation does, we do not make money in terms of, we don't supply arbitrators. What we do is we ask people who would like to be arbitrators or mediators to apply to be on the panel, and then for a membership fee that, maybe you know, I'm only a director, I can't remember the number, but something like $500 a year, you're entitled then to phone the executive director and say, I have a dispute amongst shareholders in a plastic business who need to have their dispute mediated or arbitrated. Can you give me people on the panel, their resumes and whatever else, so that we can look at them and select one with some confidence? And that's what that organization's about. Catch me afterwards, or it's Don Short, I'm in the book, call me and I'll give you the phone number. To me, it's one way around it. There are lots of organizations out there and there are lots of services. I mean, phone Rick's organization and he has a tier of people, any of the people here. But the advantage to the foundation, from my point of view, is we're not in the business. We are there simply as a facilitator to help you find a list of sensible people.
Cinnie, I think this comes back to your presentation as well.
Yeah, I think it's really a legitimate concern because in a lot of communities, everybody knows everybody. Everyone's known somebody on the bar, and all of a sudden that person becomes mediator. There are two things I think to consider. One is that mediators want to be seen as being neutral and will do a whole lot to make sure that there's a fairness that's out there. And that's the only way we're going to preserve this, because right now it's a relatively new field, and one thing we need to do is make sure that we're not bending over, that we are bending over backwards to preserve that. But ask the question, and I've been asked that. Somebody has said, I've been referred by so-and-so, and are you a friend of theirs? And if it's somebody who I hang out with and see, I'll say, yes, they are. You need to know that I do my work as a neutral and that I take a lot of pride in it. But if you have any question about it, then maybe I'm not the person for you. But I've been asked the question many times because of the bar, and I think that it's really legitimate. And you need to trust your instincts about it, and if you have any worry about it, don't do it. Find somebody else.
Thanks, Cinnie. It's 7 o'clock. I'd like to conclude by thanking Don, Justice Benotto, Cinnie, Mike for the presentations here today. I'd particularly like to thank Deborah and Laurel and Christina for all the work in terms of pulling this together so quickly and so well. Thank you very much. And I'd finally like to thank all of you for spending 2 hours here learning more about this. We all wish you well as you move forward in this area. Thank you very much.